All advice given is for general information purposes. All legal cases are different, and you should seek the advice of your own attorney before acting or making decisions. No attorney-client privilege applies to communications on this show, and no attorney-client relationship is created by calling or writing in. Attorney Rominger practices only in Pennsylvania and maintains his primary office in Carlisle, Pennsylvania.
Well, they can't gag me here anyhow. I guess I'm still allowed to have a radio show. As you guys know, I'm not allowed to talk about that case that I'm not allowed to talk about, so we won't talk about that at all. Although I do think it's interesting confluence when you think about it, that I can't relate anything to the media, but here I am, I guess, part of the media. So I guess I can't even think thoughts to myself because that may violate the order. I may need to seek clarification on that. 540-0580, Carl Rominger here, the show's weekend appointment where I answer your legal questions. For you that have no idea what I'm talking about, great. That's fine. For those of you who do, you can chuckle to yourselves or make fun of me or do whatever it is you want to do. I did have some police involvement this past Friday afternoon. I'll talk about that later in the show. I was the passenger in the car, though, so I was just involved in the incident. I was just sitting there minding my own P's and Q's. We'll talk about that later. 540-0580, you call me with your legal questions. We'll get them answered here on the air. And I've got attorney Steve Snyder floating around. How are you, Steve?
Good, Carl. How are you doing?
Good. I just shot sporting clays with Steve this morning. Steve forgot his hat, so the sun was bothering him. Is that correct, Steve?
That's correct.
And, we shot okay. Yeah. Your son's probably the best shot out there, right?
Yeah. I have a son who's an expert.
Well, I'm going to complain about one thing. What did I shot 19 for 25. I shot 17 for 25. I shot 18 for 25, and then I managed to get a 9 in one of the quads. So how did that happen?
I don't know.
You were talking in my backswing.
Okay.
All right. You want to hang with me and answer some legal questions?
Yep, I sure do.
Bill, you're on with Carl and Steve.
Yeah.
Hey, Bill.
Hey, Carl, I told you about that house I had, that rental house down in Virginia, and the people left and owed me $5,000, and I talked to you, and you said you don't practice down there, but I could come in and look in a book and get some lawyers' names down there. I think that ended up being more money than it'd be worth, but what about if I told my property manager down there to, in my name, go to the small claims court and then pay about $500 and work it out that way? What do you think?
Well, it's quite a possibility. You have to be careful. Like, for instance, here in Pennsylvania, a person can't represent another person in court, but there is a rule for small claims court that allows a designee of a business entity to represent the person in small claims court, just to make sure you have the right paperwork filled out in advance. But it's certainly a viable way of doing it.
Thanks.
All right, Bill. 540-0580. Jim, you're on with Carl and Steve.
Hi, Carl.
Hey, what's going on?
Hey, last week I went to a mediation hearing. The judge said, you guys need to work this out, and he left the room.
Okay.
I sat down with the plaintiff's attorney, went over all my paperwork, showed him that his plaintiff would be wrong, and he said to me, well, you fax me your file, and I'll recommend that my plaintiff dismiss the case. Do I want to do that? Do I just want to fax him my entire case?
He wants you to fax what to him? I mean, what does he mean by your entire case?
Well, all my documentation that proves that the plaintiff is wrong.
Well, theoretically, in discovery during the course of the case, he can request it of you anyhow.
Yeah, okay. So there's no detriment to me to just fax him everything I have.
For the most part. Now, obviously, we might. I mean, how would I say this? You're representing yourself, so you probably don't have privileged material. It would be between attorney and client.
No.
So any of your notes, indicia, investigation, statements, things like that are probably all going to be discoverable anyhow. So I really don't see a problem. But
okay.
The caveat would be if there was something in there you didn't have to turn over. So I can think of one example of something you wouldn't have to turn over to a plaintiff until later in the case. And I'll give you an example of one thing that I can just think of off the top of my head. If I have a video surveillance tape of this scene, okay, the rules say I don't have to disclose it to the other side and let them look at it until after the deposition of the plaintiff, to prevent the plaintiff from conforming his or her memory or testimony to what's actually on video. So that would be one time I could think of something you wouldn't have to turn over to the other side, but it's really kind of tricky because it's designed to prevent somebody from, using the video evidence to create their testimony from. The theory being that their recollection should be at least somewhat similar to the video, and if it isn't, that may become evidentiary in of itself. So in the rarest of instances, I guess there are things that they could ask for that you wouldn't have to provide at least right away, but by the time of trial you would. So it's quite common amongst the lawyers, and Steve, you can correct me if I'm wrong here, to give each other everything they've got so that everybody knows what's going to come in at court eventually so they can make rational decisions.
Yeah, you're required to provide the other side with any documents that are relevant to the case. Carl's right. There might be a timing issue, but if you've indicated that you have documents that prove your side, I don't see any reason why any downside to providing them.
Okay. Now I asked them to provide me receipts. This is a credit card case, by the way, Carl. I asked them to provide me the receipts where I signed for it. He says they don't exist and we don't have to provide them. Is that how can you say I owe you money, but you can't prove that I personally signed for the items they say I bought?
Well, you may have a defense there. You may absolutely have a defense there. Of course, if we put you on the stand, you don't have a Fifth Amendment. So if you take the stand and they say, did you buy these things? If you have to tell the truth, then it is whatever the truth is. If you don't recollect, you don't recollect, but you can't go, I take the Fifth Amendment. So you could become evidentiary of that yourself.
You know, these credit card cases are interesting because the credit card company first has to establish that they had a contract with you, that a contract existed whereby they're going to lend you money and you agree to make payments. And most credit card companies don't have that. In fact, in many cases, there was never a signed document, just because of the way they solicit customers. If he said they don't exist, those receipts don't exist, and we don't have to give them to you, I think the correct statement would be if they don't exist, then he can't provide them. But if you're trying to obtain copies of stuff they have, if you get to a discovery phase, they certainly would have to turn that stuff over to you.
Okay, so I simply ask for that under discovery.
Sure.
Okay.
All right, Jim, good luck.
Okay, guys. Hey, I appreciate your time.
No problem. Always tough to be your own lawyer, though. I mean, that's. All right, guys, 540-0580 if you want to call me with a legal question, because I got Steve Snyder here, who's one of the lawyers in the office. Steve, how would you describe the brunt of what you do practice-wise?
Civil litigation. I don't do criminal law, and I don't do family law. Other than that, if you have a legal problem, give me a call and come in and we'll sit down and talk.
Jim, you're on with Carl and Steve.
Hi, Carl. Hi, Steve. How are you?
Hey,
Good.
Carl. Good.
I have a friend who just got out of jail and has virtually nothing to his name, no assets at all. I put him up in a local motel on 83, and I forgot. I actually forgot. I told him that there was a Walmart right down the road, and he could probably just walk down to the Walmart because he's almost legally blind and can't walk but more than half a mile. Walk down there, get some possibles, and get yourself started, blah, blah, blah. He didn't get but an eighth of a mile, and the staters pulled him over. Well, didn't pull him over. He was walking. He didn't walk more than an eighth of a mile, and they cited him for walking on State Road.
And he's walking on the highway?
He was walking on the highway, yes.
So theoretically, you can't walk on the interstate.
Yeah.
It's closed to pedestrians.
I'd forgotten that was a law, and then I forgot about that. I was trying to do a right thing. Well, the state police said that the road is marked, that it's motor vehicle traffic at all the on-ramps. Well, he's between them, and we looked, and there are no signs indicating that. Is that arguable?
Yeah, it is. A lot of times with the signage, you have to show notice. But the burden, interestingly, even though the burden is never on the defendant in a criminal case, magically the courts have said, well, you have to come forward with some evidence that it wasn't properly posted, even though there's no burden on the Commonwealth. So the answer is, yeah, what you would want to do is show the judge basically, here's where he entered the highway, this is what I saw, and had I seen a sign like that or any indication of it, I wouldn't have been here.
Okay. The fact that he's a felon, and they probably ran a missile on him and saw that he had just gotten out, I would think that persuaded them to go ahead and just keep him in the system. So I'm wondering, is it worth his time to fight it? I don't think he's mentally capable of fighting it the way I probably could.
Right. And is this going to affect his probation?
No, he's not on probation.
Okay.
He maxed out. He has no probation, no parole. He's clean, trying to get a good, fresh start, and he got swept up. And I'm wondering, should he just go ahead and pay the fine and put it behind him?
Probably.
Okay. Fair enough.
All right, my friend.
Thank you much.
540-0580, Carl Rominger here. I got Steve Snyder with me answering your legal questions. If you ever need a lawyer, you want to find out more about us, go to romingerlaw.com. I'll see you guys after the break. Hey, welcome back. Carl Rominger here, of course. 540-0580, answering your legal questions. And let's take a little opinion piece here. Jeff, what do you want to talk about Trayvon Martin?
Well, I'd like, Carl, the last few days I've heard some comments. I'd like to sort of just make 4 little brief comments. They're not my comments, but I'd love to hear you and Steve toss them back and forth or give your view on them.
Well, here's my thought on the Trayvon Martin trial. And I said this to somebody else, and maybe I read this on Facebook, I'm not sure. But trials are not strictly searches for the truth so much as they are about who can prove what, and we set burdens for each side. And so we're never going to know what really happened. There's only 2 people who really know exactly the entire story. One's dead, one's alive.
Yeah.
And even then, even if they were both alive, we might find that they legitimately have different versions of the events, even that they truly believe. So I can have a conversation with my girlfriend, and at the end of the conversation, the 2 of us can take something different from it and be sure that the other one would have thought it was obvious, right?
Sure.
And that's just normal human perception issues. So what we do is we try to figure out what happened, and because we live in a society that tips against, at least theoretically tips against placing people in jail, we put the burden on the government of beyond a reasonable doubt to prove the crime. And then we also say that where self-defense may exist and there's any evidence of it, it becomes the government's burden to also disprove self-defense. Further, in Florida, he's entitled to a unique hearing called an immunity hearing. Bob Durgan quite often says, why does somebody have to go on trial and defend themselves after they've defended themselves? What sense does that make? So the Florida legislature has granted a process where a judge does an initial review of the case, takes evidence, and can find that the defendant, if it was likely, not beyond a reasonable doubt, but just likely that the defendant was defending himself, he can grant the defendant immunity from trial. And he just wins, basically. So Trayvon Martin's trial may end with Mr. Zimmerman being found to have a grant of immunity by the judge. And if that's the case, he can never be tried because that's a bar to trying him for the murder. Mm-hmm. On the other hand, if the judge goes, I'm not certain it was self-defense to grant you immunity, I'm not saying it wasn't self-defense, though, and then a jury has to still be convinced beyond a reasonable doubt that it wasn't self-defense under the standard ground law that Florida has. And I saw that they recently granted immunity to a fella down there. Somebody stole his car radio. He caught him in the act. He chased the guy. The guy had several car radios in a sack. He ended up stabbing the guy to death and claims that the guy took a swing at him with a sack of radios, but there was no other witnesses. And, of course, the government charged him with murder, saying you can't chase somebody. And the court said, no, he can chase somebody and he can follow, So it's kind of like the Trayvon Martin case, although in that case he was chasing somebody who stole something from him. And put himself in that situation and where he had to end up standing his ground. And that's kind of the argument that Zimmerman has, is that, well, even if you don't like what I did or you don't think what I was doing was kosher, it doesn't matter because once this incident started, however I got there, since it wasn't strictly illegal, I was entitled to stand my ground. Now let me back off for one more second here. I'm also concerned about the racial perceptions in this case. There seems to be a lot of interest in various quarters on creating this into a case about race. And I say this half jokingly, but I truly believe it to be true. If it had been a non-Hispanic white male who stabbed Zimmerman or shot Zimmerman, we would get a story that it was a Hispanic male attacked by a white man. Instead, conveniently, this has now been made into black and white politics, and we just sort of pretend that Mr. Zimmerman isn't Hispanic anymore for purposes of this racial divide that some people are trying to create in the case. And I don't even think it matters that he's Hispanic, except it's just interesting that suddenly just disappears from the equation. He just becomes a white male in some people's minds. I also think very interesting in the case is how the police did not initially bring charges. Police officers rarely just let somebody go after they shoot somebody if there's any theory or reasonable chance that they're guilty of a murder. So even if the Florida cops are a little gun-shy, no pun intended, because of the stand your ground law, I can't believe they just let this guy walk out of custody if they didn't, based on the initial crime scene investigation and observations of him and his body, figure that self-defense played into this.
Well, one of the things that I heard brought up wasn't I didn't see the press conference that the special prosecutor somebody said performed. I won't use that. I didn't see it. She started out by saying, "Well, I want to be quite honest," and the person was saying this on the radio says, "Well, what did she mean? What does she mean in the past that she's not been honest, or that she's sometimes honest? But now she's going to be quite honest."
Well, there's a
okay. Somebody can say, "All right, maybe she just misspoke. That's not the biggest thing." I understand she prayed with the family. I'm surprised the churches and state separate people that go nuts over that aren't waving their arms and saying, "What is she doing?" And I have a problem, Carl. And of course, like you said, opening up, there's two people that really know, and one of them will never be able to tell his side. Certainly, it wouldn't be solved here. I had a big problem when he did it with the president weighing in on this. They're going to try to. I'm assuming I guess it would not necessarily have to go to trial, like you said, but if it does, first of all, well, that really does a lot for the jury pool. And two, after watching what happened with Casey Anthony and that fiasco where they wouldn't even release the people's names for months later, who would ever want to be on that jury?
Right.
I mean, especially if you think, hey, this thing could get, he could be innocent, and I might have to go into hiding. So that's all I want. I just wanted to sort of hear you and Steve kick that around. You really enunciated really well on it. But an amateur like myself, when I heard that brought out about the special prosecutor, I said, well, why would you stand up and say, I want to be quite honest? I mean, when somebody says that to you, now you've been doing what you've done probably a good while. Doesn't that throw up red flag? I'm not saying.
Actually, there's a. It escapes me. It escapes me at the moment, but there's actually a term for it when you say something along those lines, like I know that people accuse lawyers of being sleazy, but we're not, and let me explain why. In other words, when you point out the fact that there's something wrong with you, but in this case it's not wrong with you, or that you're being truthful, or you're being very honest this time, but you're not quite saying it that way. There's a terminology for it. It's considered very poor communication technique. Number one. Number two, some observers sometimes believe it's kind of a quasi-admission that you're not being completely honest.
I'll bet that Zimmerman now wishes that he would have known Carl Rominger at the time and not talked to police, because who knows what he said there. I know that.
No, he should have done, and we've talked about this before, what he should have done was given name, rank, and serial number and asked to have legal counsel. Yeah. And every idiot out there, and I use that word, jokingly a little bit, thinks that somehow they have to talk, or if they don't talk, it'll be considered. Pre-arrest silence can only be used against you in a very rare circumstance. Post-arrest silence can never be used against you. Pre-arrest silence can only be used against you under the following circumstance. When at trial, you as a defendant basically go in and say, the police did nothing to investigate this case. The police didn't do anything. They didn't talk to anybody. They didn't do anything. And then it becomes fair for the police to say, well, before we arrested you, we tried to talk to you. And don't get into the detail, but the courts have held that pre-arrest silence, under where it's been made an issue by the defendant directly at trial, the fact that they invoked silence pre-arrest is admissible. But post-arrest silence, post-custody silence particularly, is not generally admissible at all, and so the jury's never going to learn about that.
Yeah, and fact, I just saw a column that somebody wrote. I don't even remember now. I read it in the last few days, and the person's point, it just reminded me of something you had said weeks ago, maybe. By the way, when the police are doing this, they're not your friend. This isn't like talking to your wife or your boyfriend, girlfriend, whatever. They're not your friend.
Do you want to do this the easy way or the hard way?
They're out to get information. They're not necessarily. I'm not saying they're out there to.
They have a job to do. They have a job to ferret out crime. Now, listen, police officers every single day, and I hope a few of them are listening right now, every single day use great interrogation techniques to ferret out all kinds of wrongdoing. And all kinds of dum-dums tell them all kinds of bad things they've done because they're not smart enough to figure out how to edit themselves or just feel compelled. Sometimes the officers tell me people seem to feel very guilty about what they did sometimes and just want to get it off their chest. But a lot of people aren't that bright, and they think, well, the officer kind of made me feel like if I just told him that I had marijuana in the car, that everything would be okay. And you're like, well, that's pretty good. That was very clever of him. But I don't think he literally said that, did he? And they go, well, listen, yeah, you're right. Listen, he didn't actually say that. I just thought that's kind of where he was headed with it. And you're like, well, sucker.
Yes. In other words, the officer is, instead of the officer just coming out and saying, thanks, you just made my day, you have.
Right. Go, here's a classic one. Listen, is there anything in the car I should know about? And the guy says no. And he said, well, you know what? We're here on Interstate 81, and a lot of times people your age have marijuana in the car, and it would probably be a lot easier on everybody involved if you had some, you just told me about it. And then the guy goes, oh, well, it's going to be a lot easier. Okay, well, I better tell him about it. And I don't know what that means. It's going to be a lot easier. It's going to be a lot easier to prosecute you when you hand it over to him because he's not going to be able to search your car otherwise. But anyhow, we can go on and on and on. But
I appreciate your time. And,
thank you.
Thanks.
All right, Jeff, take care.
You're a great show.
Thank you.
Appreciate it.
Thank you very much.
Okay, bye.
Steve, what do you think of the Trayvon Martin case?
Well, I was hoping I could get through this without having to weigh in. I just think it's very, very unfortunate that way too many people have weighed in already, way too early. I think you're absolutely right. This has been turned into a race issue, a very divisive race issue that it probably doesn't have to be. We have now the Black Panthers involved. We have Spike Lee involved. We have the president involved. When we should have just let the court system, run its course, and nothing's demonstrated to me initially that there wasn't going to be a full and full hearing on this. And
there's also another visceral thing that's going on that's kind of interesting is pay attention to the pictures they're running. Mm-hmm. And I believe, and what I'd like to get the exact age of Trayvon Martin in his picture, because I'm told that he is very young in that picture, 12 or 13 that they've been running. And that's not a current
picture, exactly.
Not a current picture of him. And I'm not saying that makes a difference. Bob Durgan sometimes says you should have to go to trial in the clothes you were wearing and looking like you did at the time you committed the crime.
Yeah.
And I told Bob, I said, well, that means if you get up out of your bathroom one night because somebody breaks into your house and you shoot somebody in self-defense and you're on trial, you're going to have to go to trial with your drawers down, Yeah. He always points out that that's kind of funny. But the point being is there certainly does seem to be some perception issues going on. And so, we've got Zimmerman and we get a mugshot of him, right? And we get a mugshot. Mugshots are the worst. Remember the Nick Nolte mugshot of his DUI?
Yeah.
I mean, they're just, none of us look good in a mugshot. And a little later here in the hour, I'm going to tell you about my police interaction this weekend caused by another woman driver. So anyhow, Steve, can you hold with me through the break?
Yep.
All right, 540-0580. I'll see you guys after the break. All right, back off the national topics and on to more, how should we say, pertinent things. Bob, you're on with Carl and Steve.
How you doing today?
Good. What's going on?
I have a judgment. I went to the magistrate and I won the court case, but now I'm having trouble collecting it. And I went to a lawyer. He wanted $1,000 plus court costs. And I'm saying, is there any way to collect this thing without paying that much money?
Well, maybe. You have the judgment, right?
That is correct.
And has it been recorded in the Prothonotary's office in the county where you got it?
Correct.
And now you just need to take it to the sheriff?
Well, here's where I ran into my problem, because the sheriff handed me a stack of papers, and I have to fill them out, and I'm looking at it, and I have no idea how to fill them out. So they directed me to the library, and so I go to the library, and the lady was nice, but really not helpful. So that's where I'm stuck. I have no idea what's supposed to go in this paperwork.
Right. Basically, yeah, you need somebody to fill it out, but I don't think it costs $1,000 to have a lawyer fill that out.
Well, I didn't think so either. That's why I said thanks, but no thanks. I thought maybe $100, $200, or...
Yeah, I would say somewhere in the $250 range, probably. I mean, here's the answer. Always keep this in mind. And sometimes people, while we're glad to write letters for people from time to time or just do a little bit of bit work, it takes time to open a file. It takes time to wrap your mind around the problem, make sure you have all the parameters, et cetera, et cetera. So from a lawyer's standpoint, something that takes an hour to do, but takes all the same transactional costs to open, you know what I mean?
Okay.
Isn't as lucrative as 10 hours on a bigger case.
Yeah, I don't know if I could just weigh in. The other thing you have to remember is for the time that the lawyer's spending on your project, he's not working on somebody else's project. And we get extremely busy in our office. I think a lot of it is the result of so many people calling in as a result of this radio show. But it's gotten to the point where I'm willing to give somebody some advice if they can help themselves, and not charge somebody just because I don't have the time to do that kind of stuff. But there are situations where you need a lawyer's help, and generally I think a lawyer would charge by the hour, whatever his hourly fee is, to help you with something.
Yeah,
like
but
that.
And Steve, I wouldn't think, having done this, I wouldn't think that you're looking at more than an hour or hour and a half to basically put this together, because here's all you're doing. I mean, really all we would be doing is filling out the sheriff's paperwork for you. Yeah. And that's not rocket science. It's like anything else in the world. Once you've done it 3 or 4 times, it's
well. One of the questions I had is, I was looking, is there any boilerplate where you just look at it and you just change the words to meet the situation? And I can't find anything.
Right, and that's the answer. Is there is a lot of boilerplate out there, but even it's funny. Like you go, hey, I'd like to find like a sample complaint, and the sample complaints never cover everything you want them to. So from a lawyer's drafting standpoint, we're quite often doing a lot of customization. The other thing is we're often swapping things. So I have a lawyer friend, and she'll ask me, do you have a replevin action? And then I'll say, well, did you guys do one of these? Can I take a look at that petition? So that we can take ganders at what other people have done. And I know Steve will tell you we have a pretty extensive library of past work we've done in the office that we keep, as does any other lawyer. So, but I tell you what, 1,000 sounds clearly excessive. If you told me 500, I would tell you that doesn't seem obscene. But I can't imagine that it would cost more than around $200 to $300.
Why don't you call us Monday morning and make an appointment, come in?
What's your number?
241-6070.
241-6070?
Yep, that's the office number in the 717 area code.
Thank you.
All right, take care. Always fun. Let's see. Deb, you're on with Carl and Steve. Deb, are you taking a shower?
I'm not.
What's going on there? Deb.
Hello?
Yeah, you're on the air.
Hi there. How you doing?
Good.
Carl? I haven't talked to you for a while.
What's going on?
I have a friend. What this is about with the racial things you were talking about earlier, what about when the shoe is on the other foot? I have a Caucasian woman friend who's actually a good Christian woman, and there is no way she would have done what these people said that she did. We're both company drivers over the road, and we both work for large trucking companies. She was delivering at a consignee, who's also another large chain, and one of the young fellows there was of an ethnic background, and she said he was a nighttime driver, N-I-G-H-T.
Right.
What he went to his manager and said was that she called him the N-word. And out of this, the manager called the large trucking firm and said that she could no longer deliver on any of the properties of these consignees.
Uh-huh.
And the trucking company fired her. She has since learned that other drivers have been banned from certain properties, and they are still working. Now, I feel she's being discriminated against. That's my own personal feeling.
Mm-hmm.
And I said, I know somebody who can answer this.
Well, the short answer is, I guess how this becomes an issue because sometimes the contractors and the owners of different companies, etc., get a report of something and they have to act on it because if they don't, they open themselves to liability. So what they should have done, however, was an investigation. And I don't know what the remedy is when they don't do a full and fair investigation. I suspect if she found that she had to be fired and they hadn't done that she may be entitled to unemployment. I'm not sure, however, that she can sue directly for discrimination unless she could show that people of different races have been treated differently in similar situations.
Okay. Well, what about male-female discrimination?
That's a possibility as well. And by the way, just a side note here, this comes up quite frequently. People go, my boss, he's mean to me because I'm a woman, and he mistreated me because I was a woman. And the defense becomes, no, he mistreats everybody, men and women. And he's a jerk to everybody, and it's kind of funny. So keep that in the back of your head, too. If they treat her badly, but they treat the men badly for similar reasons, then there is no gender discrimination.
So, okay, the other thing is this is going on what's called a DAC report,
mm-hmm.
DAC. She's going to have a very difficult time getting another job as a driver. And with all this stemming from a lie.
Well, here's what we did one time. I mean, and of course it cost some money, but we sued a lab who gave a bad DOT drug test result.
Okay.
Because they didn't send the other sample off properly and blah, blah, blah. So they should have X'd out the result, but they reported it out and it went on the guy's DOT record. And that was our lawsuit, basically, was you botched this up. You didn't do your duty of care, and had you investigated it properly, you would have dropped the blood test results, and you wouldn't have this amphetamine or whatever showing up on his DOT record. So it would seem to me that may be the style of suit. The problem is it gets very involved and costly.
Wow. So basically, she should just eat it. And
Steve, what do you think?
Well,
I'm sorry?
This is Steve Snyder. You get into this a lot with employment issues. If you're a public employee, you work for the state or something like that, you have all kinds of protection, due process protection before you can be fired. You're entitled to a hearing, and you can appeal the outcome if you don't like it. But as an employee in the private sector, particularly in a state where you're an employee at will, you can be fired for any reason if the boss doesn't like you, if they don't think that you fit into the company profile. The only thing you can't be fired for are the protected class type things. You can't be fired because you're a woman or because of your race or your ethnicity or your religion. But everything else is pretty much fair game, and so it makes it difficult. The other thing that's difficult, I get a lot of calls from people that have been, they felt were unfairly dismissed from a position, and the problem is, as Carl mentioned, it gets very expensive to litigate these kind of things, and generally you're dealing with somebody that just got fired from a job, and as long as the person is able to sign up and receive their unemployment compensation benefits while they look for a new job. Sometimes, as you say, it's better to just kind of eat it and just begin to get on with your life.
All right, Deb, I think that's about the best we can do before we got to go break here.
Okay, well, I thank you much for your time, and I'm going to give her your phone number at your office if that's okay.
That's fine. Be happy to talk with her.
All right. I appreciate your help, guys. Thank you very much.
All right, Deb, enjoy the rest of your weekend.
Take care.
540-0580. Carl Rominger here with Steve Snyder answering your legal questions on Weekend Appointment. We'll see you in a minute. Okay, welcome back. Carl Rominger here. I got to do one thing. I have a Facebook question I promised I'd answer here. Of course, if you're one of the Facebook friends of mine, and I know a lot of you are, feel free to friend me on Facebook. You can post questions throughout the week, and I sometimes will handle them there, or I have one for the show. Carl, could you please address people carrying pistols in commercial vehicles if they have a permit to carry on your show today? I think he's talking about if you are like on a commercial bus or at work somewhere. I'm not sure what we mean by commercial vehicles, but we'll go over this. Your employer can certainly control your access to firearms in employer vehicles. And in fact, employers, like any other private entity, have the right to say no concealed carry permits on our premise. So many big corporations, for instance, bar their employees from bringing concealed carry permit or weapons in Pennsylvania on their grounds, and it's specifically in the statute. I don't have a problem with that because, as you know, a private property owner should be allowed to do what they want with their property. And if Nextel or Sprint or Verizon or whatever large employer wants to handle its property a certain way, that's the way it's going to be. Other states don't always see it the same way. Some other states have meddled in that and said, no, the right to carry extends to certain venues, including your employer's parking lot. And that maybe strikes a balance, all right? So some people have talked about, should we have a law that says you may keep it in your car and bring it to the parking lot? But for commercial vehicles, if I have a concealed carry permit, I think I can go on the bus with it. I think I can go, on any commercial transport. I obviously can't take it on an airline. We know that. I can take it in a taxi cab with me. Again, unless the owner, which would be a corporation or the individual owner of that commercial vehicle says no. Sound right to you, Steve?
Yeah, absolutely.
And Steve carries regularly, so.
I carry every day.
Actually, we're going tomorrow to an NRA. Shane, when is this NRA thing? It's tomorrow? It's from 1 to 6 p.m.
It's the Friends of the NRA.
Yeah. And I guess, are they feeding us there?
If they don't feed us, I'm not going.
Well, Steve and I are going. But, Steve, the question would, I think, Shane, how many tickets do I have left?
I don't know. I asked, what was the dress attire, and should I bring my gun?
Right. I have 3 tickets left?
Yeah, I guess. Where's Shane? Is he supposed to be here?
Right, and I have a guest, so that would make it 6.
Yeah.
We have 2 tickets left. Okay, see, now we have to do the math here. Okay, so we have 2 tickets left. So, if somebody's dying to go to this event tomorrow, let us know, and we'll screen you a little bit, and maybe we'll invite you along. So we've got 2 tickets. It would be a free event. Where's it at? The Penn Radisson? In Camp Hill?
Camp Hill, yes.
Okay. So, Steve, we'll see if we can find some folks who want to join us here.
Okay.
Let's see here. Clarence, what's your question? Clarence.
Oh, yes. I was rear-ended about 2 years ago by the guy that didn't have no car insurance.
Okay.
And I sent him a certified letter, and he came in and filed guilty. And he never paid me. And then I went to the courthouse and put a thing on his credit.
Mm-hmm.
And I still haven't heard nothing from him.
Right, so your only option would be to try to collect it. Now, if you precipitate a traffic accident right with the prothonotary, they'll also take his driver's license until he pays the judgment.
Do what now?
If you did it right with the prothonotary in the courthouse?
I'm not sure.
Because you can take that judgment to the prothonotary, file it there, and if it's a traffic accident judgment, they will PennDOT will suspend his driver's license until it's satisfied.
Oh, okay. So go down to the courthouse.
Go to the prothonotary or prothonotary's office, and you want to record that judgment there as an automobile damage judgment, unpaid.
Oh, okay.
All right?
All right, thanks.
Good luck.
Mm-hmm.
That'll get his attention, I bet. Barry, you're on with Carl and Steve.
Yes, Carl, I'm sure you remember the case approximately 2 months ago of I believe it's Cumberland County judge that ruled in favor and used Sharia law as his basis on the Islamic man that attacked someone. Do you remember that case?
I remember the case, although I'm not sure that he used Sharia law because that seems to have been taken out of context, at least based on what I've seen of it.
Okay.
And I know the judge to be a Christian, so.
Okay. My question is, can you clarify that whole deal that went down and give us an update? Because I know there have been some other states that have passed legislation barring the use of Sharia law in the United States. I had written my local representative, and he got back to me recently. I reread the letter last night before I filed it in the round file, and he mentioned that there is a judicial review board that looks into those sorts of cases. So I'm wondering if you can just give us listeners an update on that case.
Well, yeah, I don't know what's happened. I don't know what's happened exactly with that. I think the lesson in that one was sometimes judges maybe just should never try to tell people why they're ruling what they do. But at the district judge level, quite often, they're trying to help people understand, why they came to the conclusions they did. That said, these laws around the country are a little troubling. American law doesn't come from America. It comes from Britain. And we proudly incorporated British law and French law into our American legal system early on, as well as Germanic law, as well as, and listen, if you go to the Supreme Court of the United States and you sit there and you listen to an oral argument, and you look up above the judges, do you know who sits above the judges?
I have no idea.
The Ten Commandments do, as does the Prophet Muhammad.
Really?
In the United States Supreme Court, and it's been there from the time they built the darn place. And why is that? Because Muhammad was considered a lawgiver and famous legal scholar, as was many, many others. You have the draconian codes. You have, who am I thinking of? Suleiman. My point on this is there seems to be some theory, some new ethnocentric movement in this country to determine that we can't borrow law from anywhere else or look at what other people's laws are. And the courts have wisely struck those laws down to the extent that they are rooted in basically saying you can't borrow from religious doctrine. Because if you want to strike down Sharia law, then we should also strike down the ability to borrow from the Ten Commandments, because that's religious law as well. The point being is it's not really that big of an issue as long as we maintain our base American Constitution. But anyhow, surprise, surprise, Muhammad's hanging out in the U.S. Supreme Court building.
That is a surprise. Let me ask
hold, Barry. Hold on. I'll let you hold over the break here. Guys, when we come back, I'll tell you about the exciting police interaction I had on Friday with the muscle cars. 540-0580. I'll see you guys after the break.